Good afternoon, everybody, and welcome to this month's webinar. It is hard to believe that we're already in December. March seems like a bit of an eternity ago at this point. Today we are talking about beneficiary designations, and those of you who've been watching our webinars will know this is the second time we've talked about estate planning this year. The first webinar we did a few months back looked at 10 of the most common mistakes that we see as financial planners, and 5 ideas that you may want to incorporate as part of your estate planning. If you missed that webinar, if you want to rewatch it, it's available to be seen on our website as well as the rest of the webinars that we produce. Those of you who've worked with us for a while will know that we are very passionate about estate planning. We feel that it is our responsibility not just to help you managing your wealth today, but putting thought into how that wealth is being passed on to your family and your loved ones down the road. So I will pass it over to Mehul Gandhi right now to give us an introduction for Jessica.
Thank you, Lorenzo. So one of the topics that comes up often when we are sitting down with clients and having that estate planning conversation is avoiding probate fees. And also the probate process itself. And a very elegant and simple way to achieve this or to go about doing this is designating named beneficiaries. And it does at the onset seem like a very easy thing to do. However, if you are not having a little bit of thought and you're not doing this properly, you could be creating more issues down the road. So with that in mind, we've invited Jessica Lowe, who is an expert on this topic, to present to us today. Jessica is a lawyer and the manager of estate planning at Solus Trust Company. She has been a lawyer for over 10 years. And a little bit about Solus Trust. It is an independent trust company. It's the largest of its kind here in BC. And it is a company that Westmount Wealth has engaged many times in the past. So without further ado, I will pass this on to Jessica.
Just one interjection here before we get things rolling, Jessica. To keep our legal department happy, obviously, I just want to clarify that anything that you hear today are the opinions of Jessica Lowe and do not necessarily represent the opinions of Hollis or the parent company, Industrial Alliance. And on that note, Jessica, please take it away.
Well, hello, everyone. First off, thank you so much to Westmount Wealth for the kind introduction and for inviting me to present today. In their wisdom, they have asked me to speak about the topic of beneficiary designations, which is very important to know about, and it can often be taken for granted and done without too much thought. So I'm delighted to have this opportunity to now share with you why we ought to be thoughtful about beneficiary designations as part of the bigger estate planning picture. So as mentioned, I'm the manager of estate planning and a lawyer with Solus Trust, and we are the largest and longest standing independent trust company in BC, offering trust and estate services. Before we get into it, just the usual disclaimer that this presentation is offered for general information purposes and is not to be construed as legal advice for your particular needs. I would encourage everyone to obtain legal advice from your own estate planning lawyer and other relevant advisors. So what I'll be covering in this presentation are, for starters, what forms part of the estate assets and the importance of having a will, which is then going to set us up very nicely to talk about the general advantages of beneficiary designations, followed by a few quick points about registered accounts and life insurance before we get into the heart of our conversation about beneficiary designations. So to discuss what forms part of the estate, I like to use this pie chart diagram because I think it is a really good way to visualize this. So imagine for a moment here that the entire pie, so the full circle here, represents everything that's in a person's name that they own. And you'll see that there are 3 pieces that are cut out there to the right. And the reason that they're cut out of the pie is because these are assets which can pass outside of the estate. And so starting with the slice in blue there, which represents registered assets, being TFSAs, RSPs, RIFs, and a few others. So for these types of accounts, you can designate a beneficiary. And if you designate a beneficiary on those, they will go straight to the beneficiary when the time comes and will not form part of a person's estate, and it has nothing to do with their will. Similarly, for life insurance and segregated funds, if there's a designated beneficiary there, it will go straight to the designated beneficiary. And again, it has nothing to do with a person's estate. in green, we have jointly held assets with a right of survivorship. And so a quick point here that for jointly held assets, which are not between spouses, so it's somebody holding it in relation to not a spouse. So if that is the case, it's really important that there be a right of survivorship that is attached if the intention is that the surviving joint owner will receive that asset outside of the estate. So just a key point there is that when adding a joint owner, it's important to get legal advice to make sure that the intention there is specified. And so if it's a jointly held asset and there's a right of survivorship, it will go straight to that surviving joint owner. And again, have nothing to do with a person's will or their estate.
So, Jessica, as an example, then, if a child and a parent had a joint bank account, it could be set up technically in two ways. It could be just a joint account or join it with right of survivorship. Is that the idea?
That's right, yes.
Okay.
And so it's really important to get legal advice before making that set up, because it's important, first of all, to clarify what's the intention behind doing that. And so if the intention is for the adult child to receive the entirety of the bank account at the end of the day, then there is something additional that needs to be done there.
Thank you.
Yeah, great question. So now what we have left here is in purple. So in purple, we have what forms part of a person's estate. And this would be covered by their will if they have one. And so the types of assets that would form part of the estate assets would be things that tend to include real estate that's in a person's sole name, a bank account that's in a person's sole name, vehicles. And so these are assets which, if they form part of the estate, they would be covered by a person's will and be subject to the probate process, I should say, and probate fees. And so in terms of their will, so it's really important to actually have a will. And I think the clearest way to explain why that is to compare the situation of having a will versus not having a will. And so if you have a will, the person who is in charge of your estate is going to be your chosen executor. And that's who you decide is going to be responsible and up for that very important role. And if there is no will, then the job of estate administrator is then going to be up in the air. So this is voluntary. So you're only going to be hoping that somebody responsible, who's probably going to be your next of kin and has priority to apply, is going to then step up and do this very big job. If nobody steps up to apply, then in that case, it's going to be the public guardian and trustee's office, which will then step in, and they are a government agency. And so they'll step in to be the one to do it, subject to their administrative fees. Next up, we have what happens to your estate assets. So in general, under a will, you get to decide who your beneficiaries are going to be and how much you want them to receive. Now, there are some limitations because under BC law, a spouse or a child has the right to challenge your will if they believe it's unfair to them. Now, in the case where you don't have a will, then the law decides for you. There's going to be a default distribution scheme based on which next of kin survive you. And again, that might not be what you actually want. So in terms of minors, now something we need to know about minors is that they're not legally able to make decisions or receive their own inheritance until they are 19. And so if parents have a will, then they can decide who will look after their children's inheritance for them if the children are minors when the time comes. Now, many parents will also use a will to decide the age that their children are responsible enough to come into their own inheritance. And many will postpone that age to an older age than 19. It just depends on how responsible they think their own children are going to be. But what if there isn't a will? In that case, the only option is that the public guardian and trustee is then going to have to step in again and to manage the inheritance of anyone who is a minor, subject to their administrative fees. And as soon as the child turns 19, then that's when the public guardian and trustee must hand it back over to them to manage themselves. Even more importantly, for those who have minor children, is the matter of guardianship. A will is really important because it allows parents to designate who they think is going to be the most appropriate person to raise their children if both parents pass away. Now, if both parents pass and they didn't have wills, then the child has no legal guardian. And when that happens, then they are under the government ministry's care until a relative or family friend applies to the court to be the guardian. That person may or may not be the person that the parents would have chosen themselves, or worse yet, there might not be anyone that applies. Finally, for those who have a preference, a will can let you decide things for yourself, like burial or cremation, and also decide on your preferred arrangements of how and where. Otherwise, the estate administrator that steps in will simply decide for you. So looking at this, you can probably appreciate that having a will can give a lot more certainty to what happens when a person passes, as opposed to leaving a lot of these things in the air. With that background in mind, we can now move on to talk about beneficiary designations. So what are some of the general advantages of designating a beneficiary on a registered account, let's say a TFSA or RSP or RIF, or perhaps life insurance or segregated funds? Now, one general advantage is that it bypasses the probate process. So you get probate fee savings and a speedier distribution. So if you recall our pie chart here from before, this is because generally the estate assets, which are in purple there, those may include accounts or real estate, and these will have to go through that probate process before an executor can access them and eventually distribute them. And that involves applying to the court, which can take a few months in that process. And before the court will be willing to grant probate, assuming that everything else is in order, it will take its probate fees of approximately 1.4% of the total estate assets. Secondly, designated assets go directly to the designated beneficiaries, not through the will. So they are not going to be subject to wills variation challenges in that way. And just a quick point that if there is a wills variation challenge, then if it goes to trial, then the court can consider what is going to other beneficiaries outside of the estate. And thirdly, in general, there's an element of creditor protection. Again, because these go straight to that designated beneficiary, whereas in contrast, estate assets first need to be used to pay for the deceased person's debts and liabilities before the net estate will go to the beneficiaries under the will, according to those wills or the will's terms. And also there's an element of privacy, as the beneficiary designation doesn't typically become a public record the same way that a probate will does. Now, for some brief points about tax-free savings accounts, as the name implies, these grow tax-free and there are no tax consequences on distribution. And you can designate a spouse as a successor holder, which is better than being a beneficiary. The surviving spouse can continue to hold it as a TFSA without cashing it out, and their own TFSA contribution room remains unaffected. As for RSPs and RIFs, some important points to note here are that if they are designated to a spouse, then no tax needs to be paid right away when the account holder passes. And instead, it's the spouse's future estate which pays tax on what's left at the time that the spouse later passes themselves. However, in general, if designated to other beneficiaries, then the account holder's estate is going to then be responsible for paying the income tax right away. For RIFs, which is what RSPs must eventually get converted into when a person reaches 71, you can designate a spouse as a successor annuitant, which is, again, better than being a beneficiary. Now, regarding insurance policies, these will be, again, tax-free on distribution. And what I'd like to talk about is an insurance planning tool that many people don't tend to know about or hear about, and that is insurance declarations. So instead of just using the insurance company's simple beneficiary designation form, there is a more sophisticated way of planning, and in the right circumstances, this can be really useful. So these are a more sophisticated way of planning that acts like a separate will for the insurance proceeds. And I just want to say that here, it is like a will, it acts like a will, but it's not a will. And so what the advantages are, though, is that like a will, you can still appoint trustees to look after the insurance proceeds for beneficiaries, subject to holding that in for a care of or for the care of beneficiaries until they reach a certain age. And you can specify what happens to those insurance proceeds if the first choice and second choice beneficiaries all pass and there's still insurance proceeds left, and still achieve the bypassing of probate.
Jessica, in the event that an individual uses the insurance policy to designate a trustee for a minor beneficiary, whether primary or contingent, what would happen there with once the child turns 19?
Yeah, so sometimes on the beneficiary designation form, there might be a blank space that says that you can indicate a trustee if you have chosen beneficiaries who are minors. Now, it could be really tempting to just put in a family member's name there and think that your job is done and that you've got a trust in place now. But some issues that people aren't aware of is that when you do that, you run into a number of different problems. So first off, what happens if that trustee is later not willing to act or is unable to act? And then what happens? Secondly, what is that trustee meant to do with those insurance proceeds? How are they supposed to be holding and managing those proceeds for the care of the beneficiaries? There's not going to be any terms that are specified in approaching it in this way. And then thirdly, that trustee will not be able to legally use the insurance proceeds themselves for the care of the beneficiaries, but rather only being allowed to use any income generated from those proceeds. And then the kicker here is that your beneficiaries will still be receiving those insurance proceeds as soon as they hit 19. And so a lot of different questions that are not answered by taking that approach. But thanks for the question. That's a really good one. Okay, so now that we have that bit of background knowledge there, we can have some fun here and play a little game of beneficiary designations, helpful or hurtful. And so I'm going to be outlining 4 different scenarios with different families, all fictional, of course, and what they do with their beneficiary designations. And then as you're watching along, you'll get to think about whether these are helpful or hurtful. So in other words, is this a good idea or a bad idea? And so after that, I'll reveal the answer to that question. So first up, we have a lovely young couple, Sam and Holly, and they are spouses, and they currently have no children. They each have a TFSA and an RSP, and they have designated each other on those. So looking at this scenario, do we think that this is helpful or hurtful? So in doing this, this is actually helpful because it will allow the assets, if one of them passes under the TFSA and the RSP, to pass to the survivor of them. So the survivor of Sam and Holly will then be able to receive those funds fairly quickly, and that will provide the surviving spouse with some liquidity to pay for a few things that they might need to right away. And so next we have Joanna, and Joanna is a mom of 2 young children who you can see there are minors, and she is single, and she has a TFSA and an RSP. And when faced with the beneficiary designation form, she writes down her 2 children's names. So is this helpful or hurtful?
Can I click on the buzzer?
Oh.
What is hurtful?
Yeah, so exactly. Yeah, you got it, Lorenzo. I'm sure that was going to be your answer anyways. Yeah, so exactly. Now, this is hurtful. It's not a good idea. This is because if something happens to the children while they are minors, then the public guardian and trustee are going to need to step in to help administer those funds subject to their administrative fees. So what Joanna should do instead, the simplest thing is to leave those undesignated, and that will actually then allow her will, hopefully she's got a good will in place, to deal with her TFSA and her RSP along with everything else that she owns. And hopefully she'll have some nice nice trust set up rather in her will, and that will all be provided for all in the same place. Now, as a footnote, I just want to briefly mention here that Joanna could potentially do some further planning where she could then still allow those registered assets to pass outside of her will, setting up trusts and a trustee to look after the funds. But when weighing the cost and benefit of this extra step, most people will tend to prefer to keep things simple and just let their will cover it the way that we have here on the slide. So next up, we have Tom, and Tom is a dad, and he is also single. And apparently he likes long walks on the beach as well, by going by that picture.
His dating profile here.
His dating profile, exactly. I'm trying to set Tom up. So now Tom has 2 adult sons, John and Nick, and Tom has an RSP. And when considering the beneficiary designation, he figures that his RSP is about the same value right now anyways as what the assets are under his will are valued at. And so he decides just to put John's name down for the RSP beneficiary and for putting down Nick as the sole beneficiary under his will. So is this helpful or hurtful?
Mehul?
Uh-oh.
It's on you.
My answer is we got a problem.
Yeah, that is right. So it's hurtful. And this is not a good idea, folks. Recall that there are income tax consequences to the RSP if the beneficiary is not a spouse. So Nick, as the estate beneficiary, is getting the short end of the stick here. He's getting less because the estate pays the income tax, not to mention all of the other estate-related expenses, before he, as the estate beneficiary, would get what's left. And meanwhile, John is going to get the RSP proceeds directly and with no deduction. And not to mention the fact that there's no saying for Tom whether or not the RSP, the funds, the value of those funds versus the size of his estate will remain the same over the years. Those things may fluctuate. And so in planning in this way, it's actually also very risky for that reason.
Right.
So what if Tom is now aware of this problem? Maybe he spoke with a friend and the friend gave him a heads up. And he figures that, hey, let's put John and Nick down as the RSP beneficiary equally. So what do we think now? And by the way, I didn't mention that John and Nick, so Tom's sons, each have 2 kids of their own. So Tom's actually a grandpa. So is what he's doing now helpful or hurtful?
My guess would be that it's better, but I would still probably pass it through to the estate ideally, instead of naming them directly for a few reasons.
Right.
Better.
So, and Mehul, did you have a comment there too?
Yeah, better, but still issues. There are some. It's not completely buttoned down. I think there's some issues.
Yeah, and you guys would be right. In fact, it could go either way. It could be helpful if things work out the way that Tom is hoping, which is that John and Nick both survive him, and so they receive the RSP proceeds equally, and they also get to save some probate fees there. But I'm going to also say that it's possibly hurtful as well, because let's say if either of John or Nick unfortunately predeceased Tom, and if Tom doesn't get around to changing that beneficiary designation, or maybe by that time he's unable to because he's not mentally capable, then it will all go to his surviving son and the children of his predeceased son. So in other words, his grandchildren from his predeceased son would then be excluded from sharing in that. So if Tom wanted to be safe about it, and let's say that his RSP value is actually quite high and he wants to play it safe, and if he also wants to be fair to his sons and their families, then what again he could do there is to leave it undesignated so that it all forms part of his estate. And the terms of his will, again, hopefully he's got a good will in place to cover all the contingencies. Then in that case, it would cover contingencies like one of his sons predeceasing and what should happen in that case.
Again, if I can just bring it back for a second to a point you made earlier, Jessica. You know, the issue in doing that, of course, the downside is now you're subjecting that RSP to probate fees, which is about 1.4%. However, as you know, planners and as lawyers will often talk to clients about, the potential for things going wrong is so much greater, and the dollar problem is so much more significant than that 1.4%, that sometimes just trying to save that small amount of money can create much bigger problems.
And
go ahead.
Yeah, and at the end of the day, if the probate fee value is that concerning to Tom, then Tom can also do some extra planning by way of a separate document. And so he would have to pay some legal fees there to set that up. But there is a way for it still to pass outside of the estate doing some extra planning. But that being said, with RSPs and eventually RIFs, people figure that they will draw down on those in retirement. And the idea being that the value probably will not be as significant, hopefully when the time comes, not for a really long time. All right, so lastly, we've got our couple here, Mike and Diana, and they are spouses. And as you can see, they have 2 little kids there. Now they have some life insurance policies which are higher in value. Let's say it's worth a couple million total. And they indicated each other as primary beneficiaries. And because the beneficiary designation form also prompted them on whether they wanted to add a secondary beneficiary in case that they both go in a common accident, they add their children equally as secondary beneficiaries. So what do we think about that?
Not Hurtful. Good. Not good.
Yeah.
Not your children.
Yeah. Good answer. Yeah. So exactly, this is not the solid plan that our couple thinks it is. If they both go at the same time and their children are minors, then again, it's the public guardian and trustee who step in to look after things, and the children will see the remaining funds at 19. So basically what we end up with are some unintended consequences based on a decision that Mike and Diana probably made without too much thought or understanding. And in my previous law practice, I often saw young parents do this before they actually got the proper legal advice. So what's a better option then? It depends. So perhaps what it depends on is how concerned Mike and Diana are about being in a common accident, because what they could do, of course, is just simply designate each other as the primary beneficiary and leave it at that. And then if they should both pass, then in that case, at least with good wills in place there, covering for all the contingencies, then it will form part of their estate and be taken care of there with their designated trustee for their children. Now, in my setup here, I did mention that the insurance policies are larger. So if Mike and Diana are concerned about saving probate fees, which let's say if it's $2 million of insurance proceeds, that's $28,000 in probate fees. And presuming that they plan to keep their insurance policies in place for the long term, then they could consider having an insurance declaration. So having a lawyer help them to set this up. And recall that this is the document that's not a will, but it functions sort of like a will, and it specifically applies to the insurance policies. And so they can use this insurance declaration to get very specific about all the possible contingencies of what would happen if they survive each other, if they don't survive each other, and what if there's a common disaster and the whole family doesn't survive.
I think it's important to note that in certain cash value policies, permanent and whole life policies that might start off with a smaller death benefit, making the will the contingent beneficiary, the estate the contingent beneficiary might make sense on onset. But as financial professionals, when we're reviewing these policies every year, as that cash value and death benefits start to grow, it might be time to start using an insurance declaration.
Mm-hmm. Yeah, great point. Yeah, so depending on timing and the value, which can change over time, the planning options that are best for a family might look different over time. And so that's why it's a really good reason to get the relevant advisors that are in your life to be reviewing things with you time and again. And I think with those at Westmount who are you guys are involved with your clients' lives regularly, and so with being really attuned to these issues, I think that's fantastic, and it's a great service to clients to help them spot some of these planning issues or opportunities along the way.
Absolutely. Well, listen, Jessica, thank you very much for joining us here today. We've covered just a small fraction, really, of all of the whole universe of estate planning. But, all we wanted to highlight today was to show that even something as simple as beneficiary designations requires some thinking behind it, because there's many ways that things can, be done improperly. So,
yeah, and I'll just add here, Lorenzo, that the way that we would fit into this picture, and a comment about the presentation as well. Hopefully, that helps you appreciate that beneficiary designations might seem straightforward, but there can be a lot of pitfalls there. And so, not to mention, of course, the ifs, ands, and buts that we didn't get a chance to cover in this presentation. So I just like to really emphasize how important it is to get legal advice to help consider when estate planning. And the will, of course, as we talked about, is a really important estate planning tool, but it is important to think about how all the puzzle pieces fit together, including what assets pass outside of the estate, and of course, whether they should or not. And so as for Solus Trust, how we fit into the estate planning is that we can help to serve in a number of important appointed roles, such as that of a professional executor, under a power of attorney, or as a trustee. And so if you'd like to explore our services, I would be happy to chat further. And so thank you so much for attending this presentation, and really happy that you could join in.
Perfect. Thank you so much, Jessica.
Thank you very much.
No, it's
See
my
you soon.
pleasure.
Bye.
Bye for now.